Thank you very much. I will try to fit in everything in the 20 minutes. As our moderator already mentioned, the primary document at the international level with regard to freedom of religion is the ICCPR, the International Covenant on Civil and Political Rights, where it says in Article 18 that everyone shall have the right to freedom of thought, conscience, and religion, and that this right shall include freedom to have or to adopt a religion or belief of his choice, and freedom either individually or in community with others and in public or private to manifest his religion or belief in worship, observance, practice, and teaching. However, as you know, not all of the 10 ASEAN countries are signatories to the ICCPR. So out of the 10 ASEAN countries, only 6 signed the ICCPR. And as you can see, so there's the ICCPR, the provisions of the ICCPR that I just read out. And then here on the screen, you can see the different countries that signed on to the ICCPR. So as you can see, only Cambodia, Indonesia, Laos PDR, Philippines, Thailand, and Vietnam signed the ICCPR. So Brunei, Malaysia, Myanmar, Singapore did not sign the ICCPR. Also, in several international human rights conventions, you have provisions that refer to the practice of freedom of religion. And this include the Convention on Racial Discrimination, the Covenant on Economic, Social, Cultural Rights, the Convention on the Elimination of Discrimination Against Women, the CRC on the Rights of the Child, the Convention Against Torture, the Convention Against Genocide, and the Convention Concerning Migrant Workers, as well as the Convention on the Status of Refugees. But as you can see, usually ASEAN member states are not always consistent when it comes to signing these conventions. The only convention that all 10 ASEAN member states signed are the Convention on the Elimination of Discrimination Against Women and the Convention on the Rights of the Child. But even with these two conventions, although all ASEAN countries signed them, some countries like Brunei, Malaysia, and Singapore made reservations on the basis that they sign on to these conventions with the understanding that it will not conflict with Islamic laws in the case of Myanmar and Brunei, and that in the case of Singapore, that it is with the understanding that they are a multi-religious and a diverse country. So when they signed on to these conventions, it was with the agreement that, with the reservation that this will not be in conflict with their laws with regard to Islam. So this brings to the point that Michelle made and our moderator also made as to the importance of the ASEAN Human Rights Declaration, considering that the countries of ASEAN are not uniformly in agreement when it comes to international conventions. It's a very good commitment when they made in the ASEAN Human Rights Declaration a statement saying that every person has the right to freedom of thought, conscience, and religion. And that they also said that all forms of intolerance, discrimination, and incitement of hatred based on religion and beliefs shall be eliminated. So in this study, we wanted to see how are the ASEAN countries making this into a reality. Where are we now in terms of implementing this aspiration to eliminate discrimination, intolerance, and incitement of hatred based on religion and beliefs? And so in our book, which is a very thick book, we looked at constitutional provisions. And we looked at the constitutional provision with regard to protection of freedom of religion. So on the screen, you can see the comparison of the constitutional provisions on protection of freedom of religion. As you would note, religious freedom is an important commitment for ASEAN member states. We all contain statements saying that we recognize the right to religious freedom, and almost all ASEAN countries put it very strongly. We call religious freedom as a right. We say that we guarantee its exercise, and we use terms such as shall and should respect the practice of this religious freedom. The only exception is with Brunei. As you would note, in Brunei, instead of saying that it's a right for every person to practice a religion of his or her belief, they say that the official religion of Brunei Darussalam shall be the Islamic religion. All other religions may be practiced as long as it is done in peace and harmony with the religion of Islam. So they use softer language when in terms of the religious freedom of persons professing religions other than Islam. But for all other countries, you will note that they put it very strongly. For instance, for Indonesia, it says that the state guarantees all persons the freedom of worship, each according to his or her own religion or belief. Moving on to the declaration in the Constitution of the relationship between religion and the state, we found also that the ASEAN member states have different provisions. For 5 countries in ASEAN, there is a clear preference for a specific religion. In the case of Brunei, Cambodia, and Malaysia, they have express provisions. For Cambodia, it is stated that Buddhism shall be the state religion. For Brunei, it says that the official religion of Brunei Darussalam shall be the Islamic religion. For Malaysia, it says that Islam is the religion of the Federation. For Myanmar and Thailand, they do not expressly say that Buddhism is a state religion, but they do indicate a preference for Buddhism. For instance, for Myanmar, it says the Union recognizes the special position of Buddhism as the faith professed by the great majority of the citizens of the Union. For Indonesia, as you know, there is no mention of a specific religion, but there seems to be a preference for monotheistic belief. So it says that the state shall be based upon the belief in the one and only God. For Laos, PDR, Singapore, and Vietnam, there is no provision in the Constitution indicating a preference for a specific religion. For the Philippines, it is the only ASEAN country that provides for a clear separation of church and state. So the Constitution of the Philippines says that the separation of church and state shall be inviolable. Now looking at the factors that influence prosecution or persecution in the region, persecution or discrimination in the region, we highlighted 3 factors. The first one is politicization of religion. Politicization of religion is when religion is invoked in political discourse for political aims, perhaps to gain votes, to gain legitimacy, or to discredit your opponent. So we found this to be a serious concern in many countries in ASEAN, most prominently in Malaysia, in Myanmar, and also in Indonesia. I'm sure Pak Zain will talk more about that later. Another side effect of politicization is that groups have found it to be politically expedient not to criticize religious extremism. So they choose not to criticize religious extremism. Another factor that also contributes to the rise of persecution or discrimination of religion is ethno-religious nationalism. So ethno-religious nationalism is a social movement that claims to speak in the name of the nation and which defines the nation in terms of religion. So it creates a high level of political animosity such that if you are not part of that religion, then you are viewed as outside of the nation. So for instance, just to give an example, if you are not part of Islam, then you are seen as not part of the Malay people. And then a religious dissenter can be viewed as somebody who is a national traitor and not just somebody outside of that religion. This was noted most prominently in Myanmar and in Malaysia. For instance, in Myanmar, they have a nationalist movement, the Ma Bata, which is calling for restriction of interfaith marriage or conversion from Buddhism. And then finally, we highlighted weak rule of law. The strength or weakness of rule of law in a country contributes to religious persecution and conflict. Usually this is found in a transitional period in the states going through a transitional period, for instance, after the reformacy of Indonesia, where the government is weak or is building its legitimacy or it's building its system. So religious extremists exploit emerging democratic space, and the state is either complicit or not in the position to defend the persecuted groups. Now, we see this in Myanmar after 2011, as the government moved towards democratization, there was an increase of violence against the Rohingyas and Muslim groups even outside of the Rohingya. And so this gives rise to unequal application of the law. Also, related to what Pak Zain and Professor Wayan will later on discuss, and the main topic of this session, weakness of rule of law also is related to decentralization, because decentralization can be a double-edged sword, because if you think about it, decentralization is a good thing because it gives the local government a chance to respond more appropriately to issues that arise. So because they are in that locality, they are more familiar with the issues and they know better on what are the appropriate measures to take when problems occur. But with regards to freedom of religion, we found that there can also be a negative effect, where, for instance, a particular locality favors a religion because it's the practice of a majority of religion, or perhaps just because the state is not in a position to ensure that national policies are enforced uniformly all over the country. So we look at states that notably have varying enforcement of freedom of religion at local or the regional level. And I will be talking briefly about Lao PDR and Malaysia before I will hand over to Pak Said to talk about the Indonesian context. So in Lao PDR, again, the main legal document governing freedom of religion is the Constitution. And the Constitution of Lao PDR says that Lao citizens have the right and freedom, to believe or not to believe in religions. It also states that the state respects and protects all lawful activities of Buddhists and all followers of all other religions. And then finally it says that all acts creating divisions between religions and classes of people are prohibited. Now if you notice, I highlighted some few words, including lawful and the last sentence. All acts creating divisions between religions and classes of people are prohibited. Because this was used as a basis for local authorities to say, sorry, you cannot do this practice because it's not lawful. Or else they could say, no, you cannot hold this activity because it will create division between religions and classes of, religions or classes of people. So for a while, there were a lot of reports of religious persecution in Lao PDR, including forced conversion or prohibition from proselytizing to other religions, because this would create division. So in 2002, the government of Lao PDR came out with a decree on management and protection of religious activities, where they assured that yes, the country respects and protects legitimate activities of believers. So the decree is the principal legal instrument for the management and protection of religious activities in Lao PDR. It empowers an agency, the Central Lao Front for National Construction, or the LFNC, to manage all matters concerned with religious activities, with the aim of making religious activities conform to laws and regulations and ensuring the exercise of the right of Lao people to believe or not to believe. So they created this law to say that, yes, we respect religious freedom, and there is going to be an agency, the LFNC, which will ensure the exercise of the right of the Lao people to believe or not to believe. So the responses with regard to this decree, at first it was positive. It was said that when Decree 92 was introduced, it was at that time a step forward in advancing the freedom of religion or belief. So it was a good thing. It legitimized many activities that were previously regarded as illegal. So it made legal activities that people were not able to do before, such as proselytizing, printing of religious materials, owning and building houses of worship, and maintaining contact with overseas religious groups. So after the passage of the decree, these activities were already allowed. But it also institutionalized the government's role as the final arbiter of permissible religious activities, because as I said, it gave the LFNC the power to regulate and monitor religious activities. Now, looking more at the negative effect of the decree, it was noted that several obligations and duties imposed on religious communities are vaguely worded, rendering the decree susceptible to discriminatory application. So when the law is not clear, it gives local authorities or people who are going to implement it a wide latitude to put in their own interpretation. And then also the procedures for registration and approvals are complicated and restrictive. And also because if you recall the ICCPR and the general comments with reference to the ICCPR, it says that registration of a religion should not be a condition for you to be able to practice. So the requirement to register an organization should only be done for that organization to have a legal personality, perhaps to get benefits with regard to if there's tax exemption or anything related to that, but it should not be a condition for religious practice. So they noted that 92 decree is very restrictive in this regard. And then, in the decree, the powers given to government authorities over the practice of religion are too extensive. So they thought that the government was given a wide avenue to control religious freedom. All of this resorted to an equal application of the practice of religious freedom from region to region. And then it was noted that there is a need for comprehensive guidelines for local authorities to avoid misunderstandings or misinterpretations on the correct implementation of the decree. Because it was noted that there has been a decentralization, and while in the larger urban areas, such as the capital city, they experienced little or no overt religious abuse, and reported an improved atmosphere of religious intolerance, the case was different for the urban cities, for the communities that are outside of the urban areas. So while large Protestant and Catholic communities of several provinces reported no difficulties with authorities, and the relationship between Christians and authorities were regarded generally as amicable, religious minorities in certain rural areas experience abuses inflicted by local authorities. So they experience nonviolent persecution in the forms of local officials denying education benefits to children of Protestant minorities because of their religious belief. For instance, 19 children from Christian families in Saravan province were reportedly not invited back to start schooling in 2010 after their families were evicted from their villages as a result of their Christian faith. So the families were forced to live in the forest without access to healthcare and limited water resources. Also, in June 2012, the Pim District Military Command discharged 2 men from active duty in the village security forces after learning that they had converted to Christianity. Also, a former district governor in Bokayao province reportedly failed to receive his retirement pay. So he did not receive his retirement pay after he converted to Christianity. Also, some Christians faced resistance from provincial officials when attempting to register their newborn children. Thank you. So with regard to violent persecutions, there were instances of closure of places of worship, forced renunciation of faith, enforced eviction and attacks against properties, arrest, arbitrary detention and imprisonment, and also involuntary disappearances. Now moving on to Malaysia. With Malaysia, it is more complicated because although there are provisions in the Constitution protecting freedom of religion, as you can see on the screen, the Constitution also provides that aside from this, the state also has a wide latitude with regard to the religion of Islam. So the state has the power to regulate Islamic law and personal and family law. It can create and punish offenses related to Islamic practice, and then it can also regulate the constitution, organization, and procedure of Sharia courts, and it can control the propagation of doctrines and beliefs. So these are the powers of the state with regard to Islamic practice. So as you can see, the practice of religion in Malaysia is regulated at the state level. So naturally, this would mean that laws pertaining to the practice of Islam will vary from state to state. For instance, for apostasy in the state of Terengganu, it's a capital crime. It's a crime that's punishable by death if you convert out of Islam. So you are an apostate. So you can be charged with a capital offense, although the law is not yet enforced because its constitutionality is being questioned, but there is that law. In all other states, the crime of apostasy can lead somebody to be detained for religious rehabilitation. Finally, because I'm running out of time, not only the effect of the state having the power to issue laws is that it also creates tension between the Sharia courts and civil courts. So the Constitution states that the courts referred to in Clause 1, which is the High Court, shall have no jurisdiction in respect of any matter within the jurisdiction of Sharia courts. So if it's within the jurisdiction of the Sharia courts, the civil courts are not supposed to take cognizance of this case. Now, it has been noted recently that there has been a more assertive enforcement of state Sharia laws into areas even beyond Islamic family law, and that even matters that relate to non-Muslim families are being resolved in the Sharia courts. For instance, in 2012, a Christian Indonesian woman was convicted by the Penang Sharia court for kalwat, or close proximity. So even though she's a Christian, she was tried before the Sharia court of Penang. And then also in Indira Gandhi, the Sharia court granted custody of the children to the Muslim father who converted to Islam after his marriage, which had been solemnized under civil law and not Islamic law. So his marriage was celebrated under the civil law and not Islamic law. So the Sharia court had no jurisdiction to grant custody orders in a non-Muslim marriage, and yet it took cognizance of the case and gave a ruling. So thank you very much.